All right, let's go back on the record. Hope everyone had a good lunch. We're going to pick up where we left off. OMC, we just released witness Josh Reeves. You don't have any other witnesses, do you, Mr. Hall?
No, Your Honor.
Okay, then we will move on to staff. Staff, you may call your first witness.
Thank you, Judge. Staff would call David Summer.
Mr. Summer, if you'll come up and raise your right hand to be sworn when you get to the witness box. Do you solemnly swear or affirm that the testimony you're about to give at this hearing is the truth?
I do.
Thank you. Please be seated. Ms. Myers?
Yes. Mr. Summer, please state your full name and spell it for the record.
David Sommerer, S-O-M-M-E-R-E-R.
Thank you. And where are you employed and in what capacity?
I am employed by the Missouri Public Service Commission, and I am the manager of procurement analysis.
And are you the same David Summer who prepared or caused to be prepared rebuttal testimony in this matter that staff is marking as Exhibit 300?
Yes.
Do you have anything you wish to correct in this testimony?
No.
So if I asked you the same questions today, would your answers be the same?
Yes.
Is the information in these documents true and correct to the best of your knowledge and belief?
Yes.
Thank you. Your Honor, staff would offer Exhibit 300 and tenders Mr. Summer for cross.
Any objections to admitting Exhibit 300, Mr. Summers' testimony, onto the hearing record? I see none. Therefore, Exhibit 300, Mr. Summers' testimony, is admitted onto the hearing record. Go ahead. Or did you already tender the witness?
I did tender the witness. Thank you.
I apologize. I have first Summit to do cross-examination.
No questions, Your Honor.
Any cross-examination from public counsel?
No questions.
Any cross-examination from OMC?
No questions, Your Honor.
Okay, well, I have a few questions, and I'll try and be brief. And unfortunately, this largely stems from my lack of understanding as to how the cash-out provision works with the ACA. So I was hoping that you could explain that to me in very lay terms so that I can get what part of it is going through the ACA and from at least what I've read, that how it's reconciled.
Certainly. So the ACA is fundamentally a comparison between actual gas cost and billed gas cost. And that's done on an annual basis. It's required by tariff in the Purchase Gas Adjustment Clause. So in essence, and this is oversimplifying it, but you take the invoices that were paid by the company for natural gas, and you compare those invoices or actual cost with the PGA revenues that were billed to the customers. In a perfect world, that comparison would lead to around zero. There would be no under-recovery of gas cost or over-recovery. There always is going to be some difference in the estimated gas cost rate, which is the purchase gas adjustment rate, and the actual gas cost incurred by the company. So that's the ACA balance or ACA account. So where cash outs come into play, and they're typically part of the transportation provisions of the company's tariffs, is there's a recognition that the transportation customer can't perfectly align what it uses at, let's say, a plant or a hospital versus what its marketing company delivers to the city gate or the entry point to the distribution system. So those two numbers have to be reconciled in some way. So you might ask yourself, what happens when a particular transportation customer burns or uses more natural gas at the meter versus what the marketing company brings in to the distribution system of the gas company? And that would be, let's call it an under-delivery, and the company has to supply that gas to the plant or to the transportation customer on a temporary basis by buying supply from, let's say, a gas producer. And that's how the plant continues to operate, even though it hasn't brought in enough gas for itself. So how is that process reconciled in terms of the ACA process? You've got now invoices that reflect not only what is being burned and consumed by residential and commercial sales customers, but part of that invoice reflects gas costs that have, in essence, been borne by the company, and the molecules have been sent to the plant to make up a shortfall. And there is a monthly provision that mathematically compares the entire usage for a particular transportation customer at a hospital, again, let's say, for example, versus what was brought in or credited by the marketing company for that hospital. And to the extent that it's an underdelivery, the company would charge that particular customer for the underdelivery. And in that way, that credit or those monies that the company receives from the transportation customer for the underdelivery can come back and compensate the sales customers who have borne those extra gas supplies temporarily. So a cash out is just what it sounds like it is. It's trying to eliminate any under or over recovery on a monthly basis.
And I think I understand. So, am I getting this right, that if the cash out amount is not paid within the ACA time period, is it the general ratepayers who bear that cost?
Generally speaking, that's true, and that's a really good and important question. If the company is waiting to credit the ACA account until it receives the money from the transportation customer, those invoices are going to be borne or carried by the residential commercial sales customers. They're bearing those costs because you haven't received that cash out credit from the transportation customer. In this particular case, and I'm not exactly sure why, but it appears that some may have credited the ACA account not so much based upon collections, but based upon billings. In other words, if it bills the cash out to the hospital, okay, for $400 and some $1,000, we believe it has gone and credited the ACA account. So if it does that, who's bearing that burden? Well, it's no longer the residential sales customers anymore, it's the company, because they haven't gotten the cash. Now, that's not a typical situation, and we believe the tariffs, when reading them, would require the company to credit the ACA account when the money is received. So if you look at the tariff, it says revenues collected, the credit will happen. But here, again, we're going to have to establish this in our review, but we think the company has gone ahead through their accounting process and credited the ACA.
So, if they've done that, there's nothing to square up as far as the ACA is concerned.
That appears to be the case as long as the company holds forth with that crediting.
Okay, thank you for that explanation. I appreciate you bearing with me while I tried to wrap my head around it. Are there any questions from the commission? Okay, I hear none. Are there any questions based upon questions from the bench? I see none. Any redirect?
No redirect, Judge.
Okay, is there any reason to keep this witness subject to recall?
No, Judge, unless there's other questions from the bench.
Okay, thank you, Mr. Summer. You're dismissed.
Thank you.
Staff, you may call your next witness.
Thank you. Staff calls Kim Bolin.
Ms. Bolin, would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this hearing is the truth?
I do.
Please be seated.
Ms. Bolin, please state your name and spell it for the record.
My name is Kimberly Bolin, B-O-L-I-N.
Thank you. And where are you employed and in what capacity?
I am employed by the Missouri Public Service Commission as the Director of Financial and Business Analysis Division.
Are you the same Kimberly Bolin who prepared a cause to be prepared rebuttal testimony in this matter, both public and confidential versions, that staff is marking as Exhibit 301?
I am.
Do you have anything you wish to correct in that testimony?
I have one correction.
Okay. And where is that correction at?
It is on page 4, line 8, with the sentence that begins, "the cost associated." It should be typically the cost associated.
Okay. All right. Thank you, Ms. Bolin. And aside from that correction you just mentioned, if I asked you the same questions today, would your answers be the same?
Yes, they would.
Is the information in these documents true and correct to the best of your knowledge and belief?
Yes, they are.
Thank you. Your Honor, staff offers Exhibit 301, both public and confidential versions, and tenders Ms. Bolin for cross.
Thank you. Any objections to admitting Exhibit 301 public and Exhibit 301 confidential onto the hearing record? See no objections. Exhibit 301 public and Exhibit 301 confidential. The testimony of Kim Bolin will be admitted onto the hearing record. And I have Summit up first for cross.
No questions, Your Honor.
Any cross-examination from public counsel?
No questions, thank you.
Any cross-examination for OMC?
Briefly, Your Honor.
Go right ahead.
Ms. Bolin, good afternoon.
Good afternoon.
Do you have a copy of your rebuttal testimony in front of you?
Yes, I do.
Would you please turn to page 5 of your rebuttal testimony?
Yes.
I'm looking at lines 12 and 13. Am I reading it correctly when it says that the cash out imbalance of gas supply to OMC is included in the PGA rates paid by customers?
Yes, you are reading that correctly. That was my understanding at the time of my my rebuttal testimony.
And that you're referring to the PGA, you're referring to Summit's PGA, correct?
Correct.
Is this statement consistent with what Mr. Summerer has just testified to?
No, it is not. This is a new development that I was just made aware of after hearing Mr. Summerer's testimony.
And you're not wishing to correct this on your testimony today?
I need to find out more information. I am not for certain all the details behind this right at the moment.
I have no further questions.
Thank you, Mr. Hall. Give me just a moment. Are there any commission questions? Okay, I hear no commission questions. Before assessing whether or not we need to go in camera or not, are you prepared to talk about these costs as a breakdown, or is that information that would be better gotten from Summit?
That would be better gotten from Summit.
Okay. Can you explain to me briefly the staff's opposition to an AAO?
Staff's opposition to an AAO, one of the main reasons is we do not believe the cost should be spread to the other customers. That would be, of course, an item that would be decided in the rate case, but as it was presented by Ozark, it was to be spread to all the customers, and we would be opposed to that.
And I know I had asked earlier, and I thought I saw you shaking your head in regard to this. there's no way to grant, to your knowledge, there's no way to grant an AAO and then later in a rate case, assess those costs just to OMC.
That is what I believe, yes. I've talked to the rate design employees of the PSC, and that is the understanding I have.
Okay, can I ask why?
I think you would have to set up a separate rate just for OMC, and I don't know that you could do that.
What about if it were just spread over the transportation customers?
I have talked to the employees in the rate design division, and yes, you could spread it just to the transportation customers. But that would need to be decided in a rate case, not today.
And I know I asked this of your attorney, but that's not really testimony. So I'm going to ask you as well. Staff has not evaluated the rate impact of an AAO for this amount.
That is correct.
Okay, I have no further questions. Are there any questions based upon commission questions?
Judge, this is Commissioner Sylvie. I have a question based on your questions, or the answer to your questions.
Please go right ahead, Chairman.
Thank you, Judge. So if I'm understanding correctly, staff's opposition to the AAO is if we allowed future recovery, it would then be spread to other customers who had no part or responsibility for this decision.
That is correct.
And if we were to restrict it, the future recovery simply to other transportation customers, the effect of that would be other transportation customers are now paying for the decision of OMC and their risk management as opposed to their own risk management. Is that correct?
That is correct.
So essentially, others would be forced to pay for the decisions of OMC that they had no input in either of those scenarios. Is that correct?
That is correct.
All right, thank you. Thank you, Judge.
Thank you, Chairman. Any questions based upon commission questions? Go ahead, Public Counsel.
Thank you. Just following up on that same line of questioning, is it your opinion that the commission should spread this to just the transport customers?
Could you repeat that question again?
You know, the discussion is if they grant the AO, they could spread these costs among just the transport customers. In your opinion, is that something the commission should do, or should they just deny the AO?
I believe they should deny the AAO.
Okay, thank you.
Can you redirect?
Just briefly, Judge. Ms. Bowen, you were asked a question about staff's opposition to an AAO. And following up on that, has, from your knowledge of commission-authorized AAOs, has there ever been one granted for a particular customer's bill?
Not since I've been doing this, and not in any research that I have done.
Okay, thank you. That's all I had, Judge.
Okay, thank you. Is there any reason to make this witness subject to recall? I see no interest in that, so Ms. Boland, you're excused. And staff, that's your last witness, correct?
It is, Judge.
Okay, at this time, Summit, you may call your first witness if you like.
Judge, we will call Mr. Walt McCarter. And Mr. McCarter is on the WebEx.
Mr. Carter, can you hear me?
Yes.
Would you please raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this hearing is the truth?
Yes.
Thank you, and I'm going to ask you to speak up just a little bit so the room can hear you a little bit better. Thank you.
Okay.
Go ahead, Mr. Cooper.
Judge, we're going to mark, excuse me, Mr. McCarter's rebuttal testimony, the text portion, as Exhibit 201 for identification.
Say that what portion of marking as it?
Excuse me. Let me go at it a little differently. Mr. McCarter's testimony, the question and answer portion is all public. He does have a schedule that is confidential. And so I guess my plan was to mark the question and answer portion separately from the schedule, and then the schedule, the confidential exhibit would just be his confidential schedule, the second exhibit. So what I'm saying is that I would like to mark Mr. McCarter's rebuttal testimony, exhibit number 201, and then Mr. McCarter's confidential schedule as exhibit 202C.
Okay, thank you.
Mr. McCarter, would you state your full name for us?
Yes, it's Danny Walter McCarter.
By whom are you employed and in what capacity?
I'm employed by Summit Utilities. I'm the manager of gas supply and contracting.
Have you caused to be prepared for the purposes of this proceeding certain question and answer testimony, rebuttal testimony in question and answer form?
Yes,
Is it your understanding that that testimony has been marked as Exhibit 201 for identification?
yes,
And that the schedule to that testimony, which is confidential, has been marked as Exhibit 202C for identification?
yes.
Do you have any changes that you would like to make to that testimony at this time?
No, I do not.
If I were to ask you the questions which are contained in Exhibit 201, as also, I guess, reflected and referred to in 202C today, would your answers be the same?
Yes,
Are those answers true and correct to the best of your information, knowledge, and belief?
yes, they are.
Your Honor, I would offer Exhibits 201 and 202C into evidence and tender the witness for cross-examination.
Is there any objection to admitting Exhibits 201, Mr. McCarter's rebuttal, and Exhibit 202C, the attached schedule, onto the hearing record? I see no objections. Exhibit 201 and 202C, the rebuttal and the schedule are admitted onto the hearing record.
Judge, one other thing, we had talked about this briefly off the record, but in my opening, there had been a question of me about actions of marketers, and I had suggested that Mr. Markham would be the appropriate witness for that, and I am told that Mr. McCarter would in reality be a better witness for those types of questions.
Okay, thank you. And is Mr. McCarter the witness that I would ask if I wanted to know about costs borne by Summit?
Yes, I believe so.
Thank you. I have staff down first for cross.
No questions, Judge.
Public counsel.
No questions.
OMC.
No questions at this time.
Okay, I want to ask some questions about cost breakdowns, and I think it's probably best for the purpose of that if we go in camera. Unless anybody has any objections, I'd like to do that on the front end and handle other questions on the back end. Any objections? Okay, let's go in camera. the record. All right, unfortunately, I front-loaded pretty much all the questions I had into the in-camera portion, so I don't have a lot outside of the in-camera portion. So do any of the other parties have any questions? Are there any commission questions that are not confidential? And I'm going to assume, Mr. Cooper, that since you have no further redirect. Okay, is there any reason that this witness needs to be kept subject to recall? Okay, thank you for your testimony, Mr. McCarter, and you're excused. And Summit, you may call your next witness.
Thank you, Your Honor. We would call Mr. Phil Markham.
Mr. Markham, would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this hearing is the truth?
I do.
Please be seated. Summit?
Please state your name.
Phil Markham.
By whom are you employed and in what capacity?
I'm employed by Summit Utilities, the parent company of Summit Natural Gas of Missouri. I am the senior manager of business development for Colorado Natural Gas and Summit Natural Gas of Missouri.
Have you caused to be prepared for the purposes of this proceeding certain rebuttal testimony in question and answer form?
I have.
Is it your understanding that that testimony has been marked as exhibit, well, let me back up. Your Honor, I would like to mark that testimony as exhibit 203.
Okay, go ahead.
Is it your understanding that that testimony has been marked as exhibit 203 for identification?
Yes, it is.
Do you have any changes that you would like to make to that testimony at this time?
I do not.
If I were to ask you the questions which are contained in exhibit 203 today, would your answers be the same?
Yes, they would.
Are those answers true and correct to the best of your information, knowledge, and belief?
Yes, they are.
Your Honor, I would offer exhibit 203 into evidence and tender Mr. Markham for cross-examination.
Any objection to admitting Exhibit 203, Mr. Markham's testimony onto the hearing record? I see no objections. Mr. Markham's testimony, Exhibit 203, is admitted onto the hearing record. Any cross-examination from staff?
No questions, Judge.
Any cross-examination from public counsel?
No questions.
Any cross-examination from OMC?
I do have some questions, Your Honor. May I approach the witness?
Please, go ahead.
Mr. Markham, I just handed you a piece of paper, didn't I?
Yes, you did.
This is entitled, these are entitled as data requests that Ozarks Healthcare sent to Summit Natural Gas, correct?
I believe so, yes.
And it has questions and answers?
It appears to, yes.
And on the back sheet, it says that this was submitted by Brooke Parsons, correct?
That's correct.
Is it your understanding that Brooke Parsons is the corporate counsel for Summit Natural Gas of Missouri?
Yes.
Could you please turn to question 8? As an exercise, would you please read the question that has been, would you please read question 8 as it's typed on the page?
Paragraph 13 of SNGMO's financing application in GF-2022-0216 dated February 16, 2022 explains that SNGMO desires to take advantage of low-interest rates to fund a portion of incurred winter storm costs. Please identify what incurred winter storm costs refers to and whether OMC's disputed cash-out imbalance is included.
Thank you. Now, to avoid a long-winded question, I would like to repeat this answer, and if I have made any mistakes in my recitation, I would like you to correct me. Can you do that?
I'll do my best.
The answer was the unquote incurred winter storm costs, end quote, refer to gas cost expenses incurred during the February 2021 Winter Storm Uri, less SNGMO's weather normalized baseline forecast. OMC's disputed cash out imbalance is a part of the quote incurred winter storm cost, end quote, and is factored into the current purchase gas adjustment for the Rogersville district. Have I repeated this answer correctly?
Yes.
Could you please turn the page over to question 11? Am I correct that the response for this question says, quote, OMC's disputed cash out imbalance is factored into the current purchase gas adjustment rate for the Rogersville district? Have I read that correctly?
You have.
And is it your understanding that these are answers supplied by Summit Natural Gas to data request from Ozarks Healthcare?
They are. Yes, my understanding.
Your Honor, at this time, I would move for the admission of this, and I would mark it as Exhibit 102.
And what are you calling it?
We will call this
Data
Ozark
request?
Data Requests 8 through 11 to Summit Natural Gas of Missouri.
Is there any reason this needs to be confidential?
No. I'm trying to, for any correction from
No,
Mr.
Your Honor.
Cooper.
Has all council had an opportunity to look at it? Or,
I don't believe I received a copy of it.
These data requests were provided to staff through EFIS, which is available to all parties, and these are answers from Summit Natural Gas to questions submitted by Ozarks Healthcare.
Mr. Poston, did you want to see a copy briefly?
No, I don't object.
Okay. Are there any objections to admitting Exhibit 102, the data requests, onto the hearing record? I see no objections. Exhibit 102, the data request, is admitted onto the hearing record. You may continue, Mr. Hall.
Thank you for your time, Mr. Markham. I have no further questions.
I have a few questions, and I don't know. I think you would be the witness for this. Are you familiar with Tariff Sheet 37?
Yes.
In regard to the granting of leniency for special circumstances in transportation cases, who makes the determination as to whether to grant any sort of leniency in that regard?
I would say it's a combination of billing, customer service, operations, measurement, depending on the situation.
And what do you use to determine what a special circumstance is?
In the past, we've used, the special circumstances have been due to meter failure or inability to measure proper gas flow for a failure of regulator or telemetry device. That is what we use as our special circumstance in this case.
Is a special circumstance defined anywhere in your tariff?
It is not. I believe that it says at our discretion, so we define what the special circumstances would be.
Okay, so that's how you're choosing to define it? It's discretion as to both whether to enter into an imbalance agreement and as to what the special circumstance is?
Yes.
Do you think that special circumstances ought to be available for circumstances like this?
I would leave that up to regulatory to determine.
So like, if you're building on a 50-year floodplain, one would assume that sometime during that 50 years, you're going to have a flood. But you don't necessarily know within that 50 years when that's going to be. Is that correct?
That's correct.
Would you agree that this weather situation is similar?
I would agree that it is similar, but I would also note that it's not something that you can plan for.
Is the company's view that, is it the company's view that as a transportation customer, because you are availing yourself of the possibility of supplying your own gas at lower prices, you are assuming the risk?
Yes.
Did you have other transportation customers whose bills increased by a similar percentage? And I'm being very careful how to word that so that we don't have to go back in camera.
Based on percentage, I would say, give or take, yes. I mean, there were other customers that had substantially larger cash outs than they're accustomed to.
And this is out of, again, only 35.
That's correct.
Bear with me just a moment. Now, it's already been discussed that the way that, and this is tariff approved, I believe, but that the way that the cash out gas is charged at the highest weekly amount, you would agree that that benefits Summit, correct?
I would agree that it benefits Summit's ratepayers.
Would you explain, please?
Because the dollars collected through the cash out process are passed through the ACA.
Well, it appears to me that what OMC, at least one of OMC's requests, is to, through an accounting authority order, spread these costs out to the ratepayers. And you're nodding. I'm going to ask you to say yes or no.
Yes, that's my understanding.
But you're telling me quite in reverse that if there is a cash out imbalance that is paid, that while that money comes from the transportation customer, it benefits the larger customer base.
It isn't a benefit, it's gas that was already purchased on behalf of firm customers, and it is reimbursing those customers for the gas used by a transportation customer.
That's a little bit confusing because that seems to slightly contradict what Mr. McCarter said, unless I'm misunderstanding, that you don't plan ahead for transportation customers that are going to go into their cash out provision, that's on the daily market.
That's correct.
So how is it how is it the firm customer's gas?
Because Summit doesn't procure gas on behalf of transportation customers. So the gas that we are procuring is to make up the difference of what transportation customers have used, which is technically customer-owned gas, because the company purchases gas for the customers.
So, and this may just be my naivety, so it's all purchase, all Summit purchases are daily market purchases.
No, that's not correct.
Okay, then explain to me why one's a daily purchase and one's not.
If we're outside of our gas plan for our firm customers and we're purchasing spot market daily gas, that is outside of our plan.
Okay, so whether or not you're purchasing for transportation customers, you view any out-of-plan purchases as being for the firm customers?
That's probably a better question for Mr. McCarter and the gas supply team.
Do you know roughly how many times the special circumstance provision of tariff sheet 37 has been applied?
I would say roughly, I've been with Summit for 12 years. I would say roughly 3 to 5 times. And it's all solely been due to meter failures or regulator failures or telemetry failures.
Have you ever seen a transportation customer exceed its contract amount by this many decatherms?
Yes.
Is this the highest cash out provision that you've seen?
Without disclosing confidential information, no.
Thank you. Any commission questions? Any questions based upon my questions? I will just go to staff.
No questions, Judge.
Public counsel.
Yeah, just real quick. One of your answers to a question from the bench, you had mentioned telemetry equipment. And does OMC have telemetry equipment?
They do.
Okay. And is that something that they can see? Like, can they look and see their usage, like, on a daily basis?
They can request that information be sent to them on a daily basis, or their marketer. In this particular situation, I wouldn't be able to say if they receive it on a daily basis. I'm not privy to that information.
But you do make it available if they...
We absolutely make it available, yes.
Thank you. That's all.
OMC, any questions based upon bench questions?
Yes, briefly. Mr. Markham, Judge Clark just asked you about whether you had seen an imbalance this large in terms of decatherms, and do you recall your response that you have seen imbalances as large as Ozarks Healthcare in the past?
Yes.
Without getting into confidential matters, can you speak to the type of operation that had an imbalance that large in terms of decatherms? To clarify, not the identity of any particular transportation customer, but an industry, some idea that you can...
I've seen them industrial and hospitals of that nature, that size. We're not talking about dollar amounts, we're talking about decatherms.
Thank you. No further questions.
Bear with me just a moment. Okay, I remember the line of questioning. I did have a few more questions, and I'll give everybody an opportunity to follow up. Do you notify customers when they've exceeded their contract amount?
That would be a question for gas supply.
Do you, in a more general, do you notify customers in situations where the company needs to curtail usage?
Yes, we do.
Okay, I have no further questions. Any other commission questions? Any follow-up based upon my question?
I'm eventually going to have redirect, I guess, but
You are, I just wanted to double check, it's not usual. I usually try and get all mine done and then give everybody, but something just occurred to me. So at this point, Mr. Cooper, given that nobody has indicated they have any other questions, it is time for your redirect.
Mr. Markham, going back to the last question from the law judge, which was about notifying customers when they exceed their contract amount, I assume we're talking about transportation customers, but does that question relate to the question that Mr. Poston asked earlier? I mean, do they have telemetry that shows them what their usage is?
They have the ability to see what their daily consumption has been opposed to what they have nominated. They know what their nominations are, yes.
Yeah, so they have within their ability to access both what they themselves have nominated and what they themselves have used.
That's correct.
There was the question, and you had answered that the dollars that would be paid by, or in accordance with a cash out would benefit ratepayers, correct?
It would make them whole.
And I guess, were you here earlier today for Mr. Summers' testimony?
I was.
And do you recall that Mr. Summer described that all gas invoices essentially flow through the PGA ACA? Is that correct?
Yes, sir.
And so the cash out amounts that you receive from transport customers, they're used to offset those gas invoices essentially that are flowing through the ACA.
That's right.
Oversimplify it.
Mm-hmm.
Okay. I asked this question to Mr. McCarter, and his memory was not as clear. Let me see if yours is any more clear. But in terms of number of transport customers overall that the company has, how many transport customers does Summit have?
35.
Okay. And in February of 2021, do you remember how many ended up with a negative imbalance?
The negative imbalance, I believe, was 18 of 35.
Okay. Did those that were in a negative imbalance situation, did any of those have anything in common? And I guess particularly, was there any common marketer to a large number of those?
There were a couple of marketers that were common to those customers, yes.
That's all the questions I have, Your Honor.
Thank you, Mr. Cooper. Mr. Markham, you're excused.
Thank you, Judge.
Okay, that I have as the last of the witnesses. So at this time, I think we're going to start kind of the, go over when briefs are due. First, I'd like to address that exhibit I requested. If I want to allow 10 days to object to that before briefs, I'm looking at my calendar. Would it be possible for Summit to have that exhibit submitted by June 3rd?
We'll certainly work towards that, Your Honor. And I assume if we need to have a little bit more conversation about that, we can get the parties and yourself together for a call to talk about that.
Absolutely. Okay. Are there any other matters that need to be addressed before we adjourn?
On the nature of this exhibit, actually, I mean, I don't imagine we'll object, but I would like the opportunity to review this before submitted, so in the interest of time, in order to avoid a rescheduling of the briefing, I guess what I would propose is, Mr. Cooper is available, is it possible to provide that exhibit to the parties first before we submit it to avoid the need of a full period to provide us an opportunity to object?
Yeah, I suspect, I mean, I think I have to get into it a little bit to know when that might be, but generally, I certainly would be amenable to getting comments from parties, maybe even before we initially file it.
That's what I was thinking. It sounds like this is more of an offline conversation, though.
And as indicated before, I'll certainly make myself available if the parties have any questions they need to work out in regard to this commission requested exhibit. Now, I have initial briefs due on June 17th. Is there any reason to change that? And I have reply briefs due on June 27th. Is there any reason to change that? Okay, I see none. Both of those will stand. Is there anything else that the commission needs to address today? Well, actually, let me just go over, well, I've got everybody here. The exhibits that I have admitted are 100P, 100C, 101P, 101C, 102, 200C, 300, 301P, 301C, 201, 202C, and 203. Did I miss any? Okay, I'm receiving no response, so I'm going to assume I'm right. Is there anything else the commission needs to address before you adjourn? I see nothing. Thank you for all your time today. I know we had some technical difficulties. It's very nice to have those resolved. And we will go off the record now.